Thank you. Senator Lee.
Thank you, Mr. Chairman, and thank you, Director Mueller, for joining us today and for your service to our country. With respect to Section 215 of the Patriot Act, is it the Bureau's practice to request records or other tangible things related to Americans that themselves are not relevant to an investigation, to obtain foreign intelligence information or to protect against international terrorism or clandestine intelligence activities?
I'm not certain I understand the question. Are you talking
so when you
about
make
215? I mean, we're the applicants on 215 orders. But,
I understand. You're the applicants, and when you make the application, is it your practice to request things that themselves aren't relevant to the investigation? In other words, do you confine your requests to those things that are related to an investigation, or are they broader than that?
Well, in the 215 context, the application to the court and the court's finding defines relevance in that particular context. And as we've talked about and have been discussed the last 2 weeks. And so I would have to direct you to the orders and I know that they're not published, but the fact that the FISA court has ruled that the gathering of the metadata satisfies the relevance definition within the FISA statute.
Right, right. And so under that, with that understanding, that you necessarily do cover a lot of data that is itself not closely tied to an investigation, you can understand why a lot of people would be concerned and why they'd also have additional concerns about the fact that we've got not only secret data gathering activities going on, but also that they're undertaken pursuant to secret law, secret orders that the American people can't have access to. But if as we've been told, it's necessary for the government to collect and store really vast quantities of information, including information on Americans that is itself unrelated to foreign intelligence or terrorism investigations, then,
if I may, are you talking about the metadata?
Yes.
The telephone numbers, but I want to make certain we're talking about that, not content.
Yes, for now we're talking about the metadata. Okay. Then a lot of people have concerns about what, if any, limiting principles there are that would prevent the government from ultimately storing all information about all Americans. Meaning just collecting more and more of this metadata and holding it for very long periods of time or perhaps at some point in perpetuity. Does the Department of Justice or does the FBI have a view on the constitutionality of gathering information on Americans and storing it so long as it doesn't perform queries on that information?
I think I understand the broader question. I would say that the Justice Department believes that the program in place, the 215 program that has been upheld by the FISA court, is certainly constitutional. I would limit it to that set of facts because they're a discrete set of facts that, with the attendant protections on privacy, that I think the Department of Justice as well as the FISA court believe absolutely it's constitutional.
And at some point, do you sympathize with those who would say, even if this is metadata, the fact that you can collect that quantity of metadata, store it for a long period of time, and the fact that it can later be searched brings about a certain intrusion on privacy, even if it's a privacy intrusion perhaps not cognizable in court?
Well, and as you well know better than most, in Smith versus Maryland, it's not protected by the Fourth Amendment. So yes, sir, without a question about privacy concerns, but I would say they're de minimis privacy concerns compared to just about every other intrusion as you get more predication in an investigation. In fact, it's at the bottom level. Yes, do I think that would be concerning to people to know that there's a database? Yeah, absolutely, which is why I do believe that it's important that this is upheld by not just the Department of Justice, not necessarily just by the Inspectors General, but also by the FISA Court and Congress.
Okay. And, you know, I think it's important to remember also that the precedent you cited is, of course, decades old, and it didn't deal with the sheer volume of metadata that we're now talking about. The technologies that are at issue now didn't exist then, and certainly weren't even contemplated then. And the more you aggregate large quantities of metadata, potentially on every single American citizen, and you give someone within the executive branch of government the power to search all of that, you do give them a pretty broad view into the lives of the American people. The more data you get, the more you add to that metadata, even if any one of those data points might be itself constitutionally insignificant. Don't you think you start to approximate a point at which you start to breach a reasonable expectation of privacy?
I certainly believe there quite probably is a scale, yes. But it was the same dialogue we had 20, 30 years ago about telephone toll records, which triggered the Smith versus Maryland case. And it is the same debate, albeit with metadata as opposed to telephone toll records, but you have pretty much the same piece of data in both cases. So I would argue that Smith, even though it's not exactly the same as a telephone toll record, the proposition that was espoused by the Supreme Court and Smith versus Maryland is applicable today.
Did we have the
comparable data? Let me just put it that way.
Right. Did we have the capacity to gather, analyze, and store in perpetuity that kind of metadata on every single American citizen at that point?
It would have been tremendously burdensome to do so at that point. You could do it, but it would be wholly ineffective. One of the differences today compared to 20 years ago is it was in the telephone company's interest to maintain telephone toll data because their billing was based on telephone toll data. Today, that is no longer the case. In fact, the telephone companies see it as a burden, a storage burden, and consequently, that information that was there in the telephone companies 20 years ago may well not be there today, absent 215.
Okay. Thank you very much, Director Mueller. I see my time has expired. Thank you. And thank you, Mr. Chairman.
Senator Hirono.
Thank you, Mr. Chairman. I join my colleagues in thanking you, Director Mueller, for your service, and I extend my aloha to you in your future endeavors. I appreciate the fact that this kind of data that's collected, particularly under Section 215, could be helpful in connecting the dots. And yes, it is hard to figure out which dot might be the critical dot that helps you to foil a plot. So I have a question about, to the best of your knowledge, what are the costs of collecting and storing data gathered under Sections 215 and 702? For both your agency as well as NSA?
I would think you have to turn to NSA to respond to that question. I'm not familiar with what it costs.
But what about to your department?
We don't do the storage. NSA stores the 215 data.
What about the collecting part?
The collecting?
Yes.
It goes directly to NSA. The order directs that the data go to NSA.
So while you're the applicant for
Yes.
the collection of this data, it's NSA that I should ask about what the
Yes.
costs attendant to the data collection. Do you know how long the data collected under 215 is kept?
5 years.
Just 5 years. Do you think it should be longer?
No.
Okay.
I also don't think it should be shorter, but
Now, part of your department's FBI's purview is prosecutions in Indian country, and you talked about that briefly in your testimony. And the Department of Justice recently issued a report on investigations and prosecutions in Indian country during 2011 and 2012. And this is a report mandated by the Tribal Law and Order Act of 2010. And it seems that while there has been a noticeable increase in the number of violent crimes prosecuted, those new figures do not reflect that 1/3 of all reported Indian country crimes were closed administratively by the FBI before they ever reached the formal referral stage. Moreover, approximately 80% of those investigations that were administratively closed were violent crime related. Can you shed some light on the reasons why so many FBI Indian country investigations are closed before referral to DOJ, and specifically ways in which your department can better address and investigate violent crime in Indian country, which is still a very big problem?
Well, I think we all understand it's still it is a very big problem. And I know the Department of Justice, in particular the Attorney General and the Deputy Attorney General, this is one of their substantial priorities, which is why you see an increase of prosecutions in Indian country. I will have to get back to you on the figures relating to administrative closures. I am not certain if there has been an uptick in the number of administrative closures, why that is there. It may be consistent with the fact that we've done additional prosecutions. And with additional prosecutions, there's additional scrutiny of the underlying case, which has resulted in administrative closures. But I'd be just speculating. I'd have to get back to you with after looking at the issue.
Yes, considering that this is a major issue in Indian country, and to realize that in this report so many of these cases are closed, I'm curious to know why. So okay. Could you provide that information to our committee? Senator Feinstein had a concern about the use of drones, and particularly with regard to the use of drones by the private sector. Do we have any special or specific legislation governing the use of drones by the private sector?
I am not aware of any.
Do you think that we should be thinking about federal legislation to protect individuals' privacy with regard to the use of drones by the private sector?
Well, I think there are a number of issues relating to drones that are going to have to be debated in the future as they become more omnipresent. Not the least of which is the drones in airspace and the concerns you have on that, but also the threat on privacy. We already have, to a certain extent, a body of law that relates to aerial surveillance and privacy relating to helicopters and small aircraft and the like, which I think could well be adapted to the use of drones. But it's still in its nascent stages, the debate, and but it's worthy of debate and perhaps legislation down the road.
Especially as the hearing that we had in one of our committees, I think it was this one, where these drones can be very, very tiny but store a lot of data, and there could be cameras on it. And I think this is a burgeoning concern for many of us. With regard to the data that's collected under Sections 215, in particular, the millions and millions of pieces of information collected, NSA indicated that there were 300 queries that were made with regard to this data, and they have to forward those queries to you, and 10 to 12 in cases were referred to you.
Well, only they will refer them to us when they have a U.S. number that comes out of their query.
I think as a layperson, I'm having some difficulty understanding what the process is, what NSA does with all this information, where you come in. There's some nexus between the NSA looking at this data, 300 queries, and then forwarding to you, say, 10 to 12 cases where they see some further investigation needs to occur. So what happens to all these other cases, that other numbers that were queried by NSA?
Well, when you talk about 10 or 12 cases, these are cases where the identification of a number led to a terrorist case or corroborated other information we had in a terrorist case. But if you have NSA on a number in Yemen, for instance, and they want to know who from the United States is in contact with that number, you've got that number in Yemen, they take that number of Yemen, and they run it against the database of numbers to see whether there's any number in the United States that is contacting that number in Yemen. And when that number comes out, we mentioned a couple of examples here in, say, San Diego, they will refer to us and say that there is a number in San Diego that is in contact with this number in Yemen, which is terrorist-related. We then go get a national security letter or other paper to determine who has that number, who is the subscriber to that number. And once we get the subscriber to that number, then we'll build the investigation. That's, in simplified form, what the process is about. But absent that capability, we would never identify that person in San Diego who is in contact with the terrorist group in Yemen. And that is what we did not pick up in 2001, where the intelligence community was on a number in Yemen, and this individual, Al-Midhar, ended up being in the United States. And had we had that program in place, we might well have picked up Al-Midhar.
So in your view, in spite of the fact that there are literally billions of pieces of information collected, and in your view, the dot connecting possibilities justify this kind of breadth of data collection?
Given all the precautions, given all of the constraints on the program, given the oversight of the program, yes. But it's the program as a whole, not just the fact of the accumulation of the records, but how it is handled and what kind of information is it comes from it. I was asked earlier today, why did we miss Boston? Why did we miss Fort Hood? There can be one piece of information that comes out of it that would prevent the attack. People will say that we were not sufficiently attentive to al-Awlaki's email traffic. Had we been, we would have stopped Fort Hood. So to the extent that this provides dots for us to connect, it's very useful. Yes. You never know which dot is going to be the one that breaks the case. And to the extent that you remove the dots from the playing field, we just don't have those dots to connect.
I certainly understand that. Thank you, Mr. Chairman.